welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Wednesday, July 16th, 2025. We have a special guest today that I'm excited to share with you, who's going to be discussing a case from the Sixth Circuit about a criminal appeal he's worked on. We also have an update on a little edition of Where Are They Now from an IJ case, which itself is going to be a case we're going to discuss. And it's a victory for IJ as well. So we'll get to those in a little bit. First, a announcement. So as I've teased the last couple of episodes, we are going to be at the Seventh Circuit Judicial Conference. We're not actually part of the Seventh Circuit Judicial Conference, but we're going to be holding a live podcast on the eve of it in Chicago on Sunday, August 17th at 7 p.m. Hopefully our website with the info about the event will be up by the time this podcast is, and it's in the show notes. If it's not yet, it will be shortly. Just listen to a future episode. But I'm excited to share that we now have a full panel for that Short Circuit Live. That will be me as the host, John Wrench, my assistant director at the Center for Judicial Engagement, and also two Chicagoans. One is Sarah Konski, who is professor at the University of Chicago. She's director of their Supreme Court and Appellate Clinic, and also Chicago appellate lawyer Christopher Keeler, who is a longtime appellate lawyer in Chicago and for the Seventh Circuit. And they will both be able to share all their knowledge about the Seventh Circuit if you come to that Short Circuit Live, or of course, you can just catch it on the podcast later. So look forward to seeing some of you at that. Now, as for today's episode, I'd like to welcome my colleague, Marie Miller. So Marie, last time you were on, we were all talking about walking on the wrong side of the road and how that's a major serious crime in the state of Missouri. So serious that your client was maybe kind of charged with it, although we're not really even sure. And since you came on, we've had a ruling in the case you discussed. And what happened?
That's right. So after we got the GVR from the Supreme Court, the case was remanded back to the Eighth Circuit. And what was a 2-1 decision against our client turned into a 2-1 decision in favor of our client. So the case went back to the district court and can proceed.
That is fantastic news, and it's kind of a funny story how you got there, and also what the court had to say. But we will discuss all that a little later in the episode. But first, our special guest. So I'm very pleased to introduce to our Short Circuit audience Kyle Singhal. So Kyle is he's a jack of many trades when it comes to appellate law. But he does a lot of criminal appeals and civil rights work. He earned his law degree from the George Washington University Law School. He also has clerked for 2 different judges on the Sixth Circuit. And he clerked alongside someone that people at the listeners of Short Circuit will be familiar with, which is Keith Neely, IJ lawyer, who is actually going to be on next week's episode. So Kyle, welcome to Short Circuit. Tell us a little bit else about yourself and what you do.
Well, thanks for having me, Anthony. It's great to be here. I clerked for Judge Danny Boggs with Keith Neely, and then John Bush was appointed in 2017. I clerked for him as well, and I teach appellate practice at the George Washington University Law School with Judge Bush, and we have a great time teaching that course. I've also taught a constitutional law seminar at the University of Louisville, Brandeis School of Law. So that's it's a jack of 3 trades. That's the adjunct law professor hat. I also provide some bar exam tutoring. I work through some firms, some law schools, and privately for those who were unsuccessful the first time and need a little lift the second time around. But my day job is the practice of law. My office is based in Washington, D.C. I spend most of my time in Maine, where I am right now. or traveling to see whoever wants to be seen.
I see a pine tree behind you there. So it's very, very main setup.
There is, so that's the new Maine flag, which is actually the old Maine flag that the folks decided to readopt as the Maine flag. And so sailing and lobstering are all daily activities in the summertime. We, in terms of the legal practice, right, so the bulk is appellate work. The bulk of the hours, I should say, is appellate work. Criminal appeals tend to be wire fraud. The civil rights stuff is fun. I've got currently a good 1983 suit, at least two good 1983 suits. I've got some Bivens work. You can't call any of that good these days. And I've got a complicated Federal Tort Claims Act case that I'm litigating in the D.C. District Court, which will almost certainly be decided in the circuit. So I really enjoy that work as well. You can only do so much of that at a time. And apart from all that, I do some work just in district court post-judgment, whether it's a Rule 60B motion on the civil side or sentencing work in the criminal side. And I've had some success in the clemency sphere. So I do some advising on applications for commutations or pardons. So that's it in a nutshell.
Well, out of that universe of practice that you have, we're going to take a little slice today, which is a Sixth Circuit appeal that was recently decided, and that you are a lawyer for the defendant appellants, and it gets into some issues that we don't do too much on short circuit. We do criminal appeals occasionally, but it comes down to something that I think probably most people in law school don't think too much about or about their importance, but actually are hugely important when you get into criminal defense, and that is how you instruct the jury. Is that right?
Absolutely. The opinion talks, one of the opening lines is something like, this is fundamentally a case about a fraud scheme, and specifically a pyramid scheme, which that's how I think the case was briefed as. This is a pyramid scheme case, but then the upshot of the opinion is, I don't know why the panel says, I don't know why they bothered instructing the jury on a pyramid scheme in the first place. Why not just instruct the jury as a mail fraud case? And so that's what this shakes out as, is the panel says, well, regardless of whether there's a pyramid or not, the jury could have convicted the defendants based on an ordinary definition of conspiracy to commit mail fraud. But I want to back up a second and explore the pyramid scheme theme. So, Egypt has pyramids of limestone, right? You think pyramids, they're already spooky from the start. American pyramids are ones of Mary Kay, cosmetics and Amway supplies and Tupperware. And I think depending on how you frame it, a person's first impression, if you say, well, have you heard of multi-level marketing? They say, oh, that sounds like a pyramid scheme, right? If you ask someone, have you heard of lawful, legal multi-level marketing? They might think Mary Kay or Amway,
right,
or Tupperware, right? And I think there's a general idea that those things are okay. Millions of people have probably bought or participated in those product distribution systems. If you ask, is a pyramid scheme legal? How could I even ask that, right? People look at you as though you're asking whether genocide is good. So you'd think that there would be a bright line between lawful Amway-style multi-level marketing and illegal pyramid schemes, the kind that everyone knows must be wrong. And I think this opinion illustrates amply that there's not. The panel's opinion is that in a specific case, and likely in other cases going forward, the government would be wise not to worry about whether something is or is not a pyramid scheme. If there are false representations made, just charge it as mail fraud. But in this case, the government's theory from the indictment to closing was that the defendants participated in and ran a pyramid scheme, and so I'll tell you a little more about what they did and what the allegations were. But first, I have to comment on the absurdity of the fact that it's 2025 and we're still talking about mail fraud, right?
Right.
Who goes about their day worrying about whether someone's going to commit mail fraud against them? And I think if you look back, I think the first true mail fraud statute, 1868, some folks were concerned, and Congress passes a law that says it's illegal to, quote, deposit in a postal post office to be sent by mail any letters or circulars containing lotteries, so-called gift concerts, or similar enterprises offering prizes of any pretext whatsoever. And so, back then maybe you'd get something in the mail that sounded like a good idea, and you'd send $1 or $2 and hope that you got what was promised. And I think I can recall in early childhood seeing certain catalogs that you might send the money in sight unseen and hope you. But we don't do that anymore in 2025, and yet the vast majority, if not all, of the federal fraud prosecutions come under either the mail fraud or wire fraud statutes or the adjacent healthcare fraud or bank fraud statutes. And the title of the mail fraud statute itself is Frauds and Swindles. I love the word swindle, right? Yeah, nothing like being a swindler for Halloween. Spooky, kind of like pyramids, right? Swindlers.
And does the actual text of the mail fraud statute still today require use of the U.S. mails? I'm guessing it's been expanded to email or other ways of using interstate commerce, quote unquote.
Every indictment has, if you're going to charge mail fraud rather than wire fraud, actually requires an act where something was put in the mails under 18 U.S.C. 1341.
I see.
Now, the interstate commerce expansion is the wire fraud statute. That's
Okay.
18 U.S.C. 1343. But still, the wires, you tend to see phone calls and emails as opposed to some just more general, there was a website, something like that. And so typically the overt act, if it's a conspiracy case, is going to be, on this date, somebody got a check in the mail, something like that. Okay. So what happened here? Well, so one thing you ought to understand about multi-level marketing is that multi-level marketing people truly are multi-level marketing people. It's a lifestyle. There's cultish devotion to it. It's energetic. It's entrepreneurial. And darn it, it's American. Because what happens is, even with Amway, and this opinion in a footnote says Amway is the quote best example of a lawful multi-level marketing program. Even with Amway, the majority of people make nothing, and of those who make something, the average among all of them is under $100 a month. Right? And people either know or probably know that, and yet they're attracted to these programs because everyone hopes that they're going to hit it big. Everyone hopes they'll be the one who makes the millions of dollars. And the people at the top, you've got very wealthy people at the top of these programs who they flash checks. There's certain behaviors that look at these people doing great. And it's this American dream of finding a way out and, social mobility. So the folks that are the main characters in this story had that as their background. All right. So nobody came to this the current scheme and said we're gonna try a pyramid today. They had all been doing multi-level marketing with various degrees of success for their lives. That's what they did. So you have to wind back to 2013, and the three defendants on trial here were Rick Mikey, Doyce Barnes, and Faraday Hosinapur. So Rick, Doyce, and Faraday. And the organization, the entity, the company is called I2G, Infinity 2 Global. And they have essentially three main ideas. There are other ideas, other products, other innovations they come up with and pitch, but the three main selling points. One was this program called The Touch. Now, I said you have to wind back to 2013. Zoom 1.0 was coming out then. There was no Facebook Live. So this thing called The Touch was an idea of something kind of like that, where you'd have some sort of video streaming integrated with your social media, integrated with news, maybe email. And the idea sounds kind of cool in 2013. And if you do it right, it still sounds kind of cool now. But there was a free version, not quite the same, of this software out called QB. And these guys said, let's take that, let's make it better, let's market it as The Touch. And people can join our program, buy a subscription to The Touch, and then they can also recruit other people to buy it. They get the commissions, and that's how the multi-level marketing element gets drawn into this. Another program they had was this thing called Songstagram, karaoke app. You spin together a little vignette of you singing along to the background music. Fine. And then the third thing, and the main focus of this case, was an online casino, where now in 2013, you didn't yet have lawful online gambling in the U.S. So the thrust of the online casino was, let's get people overseas gambling at this online casino, and we can make the money off of it, and people love to gamble. So the idea was they would sell memberships at different tiers. All of these multi-level marketing schemes. You can buy in at the bottom level, or you can be an emperor. And if you bought the emperor, that cost $5,000, but only at the emperor level did you get a share of the casino profits. And Rick, Doyce, and Faraday promised, and no one alleges they broke this promise, that there would be at most 5,000 emperors. So there was a cap on the number of people who could have this membership, and they would all share equally the profits of the casino. And so some of the messaging that was later flagged as part of this, the fraud allegations was they would have these video calls to get people excited about I2G, about the company, about promoting this product and recruiting new recruits. Come get your share of the $150 billion gambling pie. And perhaps in 2013 there wasn't one, but heck, it's bigger than that now, right? So that was the idea, was that they would get everyone, that get 5,000 people to each pay $5,000, and $25 million comes in real quick. And then those people could each earn commissions by getting other people to sign up for any level of membership in I2G, whether it's just the touch or the Songstagram or the whole thing. And within months, lots of money came in. All right, and the allegations were that the defendants made certain false statements along the way about how much profit was being generated, about who was backing the touch, who was backing Songstagram. And from a simple mail fraud angle, were there false statements made in selling these memberships? Those were the allegations. Where it gets complicated is the government alleged that this was a pyramid scheme. And the catch with it is what courts like the Sixth Circuit and other courts have said in the past is a pyramid scheme is one that is destined to collapse.
Right,
when you run
like
out
a literal
of new,
Ponzi scheme,
like a literal
like Mr. Ponzi
well,
did.
so yeah, Ponzi and pyramid overlaps. That's a great question. Ponzi is where you're taking the new money to pay off the old people. So you can do a Ponzi without a pyramid, and you can probably do a pyramid without a Ponzi. But in most cases, I think an illegal pyramid is going to be a subset of the Ponzi, because you're taking the further you go down the pyramid, the more people you have to keep recruiting to generate revenue that passes up to the old people to keep them happy, right? So most unlawful pyramids are going to be subsets of Ponzi, absolutely. And actually, the government had this little pyramid chart that was the background on the TV screen at trial. So when it switched between exhibits, you had to see this pyramid with exponentially 1, 2, 4, 8, 16. And if you knew your powers of 2, you could just stare at that and practice in between exhibits. So the idea is that you run out, and so the FTC had a ruling that, there was an Amway ruling, but in the Sixth Circuit, the precedent on this is this case called Gold Unlimited. And the short version of Gold, this is an easy to understand example of a pyramid scheme, is they were selling, say, $800 worth of gold. And when you called up, you didn't have to put your $800 down. You could just pay part of that. You could just put in, say, $200. And then you could get other people to sign up to buy gold as well underneath you. And when someone else put in their $200 as a deposit on their $800 gold, you got a commission credited to you. And so eventually you could pay for your $800 just by getting other people to sign up as your recruits, which only works if nobody actually ever decides to claim their gold, right? So eventually you'd get enough commissions to where if you wanted to, you could say, okay, I've paid my $100 off, I want my gold coins now. But in practice, this would go on for a while, and eventually it came crashing down. And the Sixth Circuit says, look, this scheme is destined to collapse. The gold itself wasn't worth $800. If it were, then the company wouldn't be able to sell it at a price tag of $800 minus commissions. Right, the company was giving out hundreds of dollars of commissions. It wouldn't make any sense. You can't build in a margin big enough to pay commissions on gold, right? You can't build in that margin on hardly anything. Amway's able to do it because they're selling cleaning supplies that are probably cheaper to produce, and you can put the profit margin in there. But you certainly can't do it in gold. So was I2G a pyramid scheme? Was the casino a pyramid scheme? The government argued it was on the grounds that There were 5,000 people, at least the emperor program, the 5,000 emperors, were getting commissions as part of their incentive to join. And once you got to emperor number 5,000, that person was no longer going to be able to find any other recruits to come join the pyramid. The defendants argued it wasn't, on the grounds that everyone knew it was capped at 5,000 emperors. And in fact, none of the witnesses who came to testify at trial for the government testified that they even cared about the recruiting. They just wanted to earn the income from their share of the casino profits. And so the defense theory was that this has many features of multi-level marketing, but it doesn't have the essential element of a pyramid scheme because nobody was even trying to recruit. At least none of the government witnesses were even trying to recruit. Yes, when the recruitment happened, commissions passed upward, and that's true. But in looking at the case through the previous cases, like the Gold Unlimited case, it lacked the risk of saturation, the risk of running out of recruits. If, in fact, the government had to prove that there was a pyramid scheme, that might have mattered. But at the end of the day, what the panel says is, the federal legislature, Congress, has never made pyramid schemes themselves unlawful. The indictment wasn't charging as a statutory matter the conspiracy to commit a pyramid scheme. It was charging mail fraud and mail fraud conspiracy, and there was enough evidence here to support the guilty verdict. There were other issues that were raised about whether it was unconstitutional to charge pyramid scheme in the indictment and then sort of change the theory to one of more general mail fraud halfway through. And Judge Nalbandian writes a fairly lengthy concurring opinion exploring that, but ultimately concluding that any sort of potential variance was harmless in that respect. The takeaway, I think, if you're in business, is you be careful about what you say and what you do, because the sort of ordinary puffery, come get your share of the gambling pie, that might not be charged as fraud ordinarily was a highlight in the government's case here. And because the Sixth Circuit had previously held that pyramid schemes were sort of per se schemes to defraud under the mail-and wire fraud statutes, it made it easier for the government to win its case. One line from the opinion stands out. I think it's a little curious. I don't think it was material in this opinion, but I think I can see it being quoted down the road. The majority opinion says, in the context of articulating why the jury could have made an inference that there was proof of conspiracy to commit mail fraud, the majority says, two robbers who enter a bank from different entrances, for example, presumably do not do so by coincidence. I say, well, it might be okay for a jury to infer that if the question is whether there was sufficient evidence, but I don't know that it's right to say that's the presumption, if the presumption is innocence unless the elements are proven beyond a reasonable doubt. So I'm curious to see how that line is used in other cases outside the pyramid scheme context.
Marie, your thoughts on reading this case?
Yeah, Kyle, I'm interested. What do you think this decision did to Gold Unlimited? Do you think it kind of entrenches it more, heightens the standard? What do you think this has done?
I think it minimizes Gold Unlimited and sort of reads it away in a sense, in that it says that there's no reason that they needed to charge pyramid scheme here. They happen to say some words about it, but look, they also happen to charge mail fraud, so let's just ignore the pyramid scheme dimension of the case and affirm the convictions on that ground. One of the points of Gold was that a defendant in these circumstances might have the right to what's called an anti-saturation instruction, where you can instruct the jury that if the company had measures in place to prevent collapse, then that's an affirmative defense. No such that instruction was proposed here, but it was not given. It was one of the primary issues on appeal, and the court says, well, no anti-saturation measure can cure the misrepresentations. I think what it does is it limits gold to cases where the government is relying on the pyramid scheme alone without any allegation of a misrepresentation. Right. So if the government is going on a strictly per se pyramid theory, they can't prove anyone said anything false. All they can prove is this setup is doomed to fail, and people are therefore getting duped implicitly, not by an express promise of a certain quantity of profits. Right. The bad spreadsheets and sound bites here were that we made X dollars in profits this month, and that was overstated. At that point, I think the panel says, look, the government has evidence of a misrepresentation. That's enough to affirm on. We don't need to worry about Gold Unlimited's application to a true pyramid scheme.
Mm-hmm. And I was also interested in your thoughts about Judge Nalbandian's theory that the defendants had argued that the government had presented this erroneous legal theory about an emperor-only capped pyramid, and he goes on to say that's harmless anyway. But how much of the trial was focused on that emperor-only capped pyramid theory?
The government had an expert on pyramid schemes, right? So this sort of cuts against the narrative that this wasn't really a pyramid scheme case. The government had an expert come testify about the evils of multi-level marketing and what makes them pyramid schemes, and how this was in fact going to be something that collapsed. So in my view, it was a large part of the trial. Now, to be fair, there were other sub-counts. There were securities fraud issues and tax issues that also occupied a lot of time in the trial. But in terms of the primary, the mail fraud conspiracy counts, proving it was a pyramid was a large part of the case.
So from the jury's perspective, they would have seen the pyramid scheme allegations as prominent and mail fraud
absolutely
as taking a back seat.
Yeah, now, until you get to the jury instruction. And so if you look at the jury instruction, you've got sort of, as often happens, a modified version of the pattern instruction. The pattern instruction on mail fraud, and you knowingly participated in a scheme to defraud that had a material misrepresentation, you had the intent to defraud, and you used the mail. Right? So scheme, misrepresentation, intent, mail. And if you ended it there, it might be okay. What happens after is the court adds a bunch of stuff, and there was a lot of discussion, days of colloquy back and forth, and the court says, okay, that scheme to defraud includes the following. It sort of restates the elements of a scheme to defraud, that includes the scheme to defraud, the misrepresentation, and the intent to defraud. And then the court says a pyramid scheme is any of the following things, has a very broad definition of what a pyramid scheme is. It says a pyramid scheme is anything where the focus is on receiving recruitment rewards and promoting, interests in the venture. And then in the defense view, the kicker was, it says a pyramid scheme constitutes a scheme or artifice to defraud. So if you're the jury, all you have to do is look at that paragraph 2b of the jury instructions and say, well, did we have a pyramid scheme here? Did we have something that focuses on promoting sale of interests in the venture rather than products? And if so, we can short-circuit all the rest of what a scheme or artifice to defraud is. And Judge Nalbandian says that's not quite right. He says, no, that paragraph only allows the jury to short-circuit the first element of mail fraud, that there was a scheme to defraud, not the other elements of is there a material misrepresentation or did the defendant have the intent to defraud. I think it's fairly ambiguous. I think you can look at these and if you're a juror this is your first interaction with multi-level marketing, have no idea what exactly is necessary or sufficient to come up with a guilty verdict. But the panel disagreed.
Well, I think we've discussed maybe before on the show how jury instructions are much more in theory than how the minds of jurors actually work, right? And so I think any juror who had sat through that trial, I'm guessing, is thinking, is this a pyramid scheme? If yes, guilty.
That would, if I were sitting there, that's what I would be thinking. Absolutely.
Yeah. That my eyes, and having done almost no criminal defense ever, my eyes in reading this and hearing what you have to say is that essentially this is a mail fraud prosecution. Pyramid scheme is just kind of a sexy way to dress it up and get the jury on board. We also put a pyramid in the background of the visual for the jury to see day after day. And so is it harmless error to just keep repeating pyramid scheme when it's really about mail fraud?
Right, and I think ordinarily, if you took the case law out of it, maybe so. If you took the case law and this jury instruction out of it, and just said, "Look, we call it a Ponzi, call it a pyramid, call it whatever you want to call it." I think you say that all the time in terms of calling a fraud prosecution, you call bait and switch, whatever the term is that people hear. But when that term adopts a secondary definition that doesn't have or require proving all the elements of the mail fraud statute, then you might have a problem. And it's something where, I don't know. It's not, the multi-level marketing is such an American thing. I doubt that Congress is going to prohibit, in a clear way, multi-level marketing. It's just, how could that ever happen, right? But it would be nice for the folks involved in multi-level marketing if there were clear guidelines as from Congress and not just from FTC musings or from opinions like this on where the line was and what parameters could ensure that folks in this situation didn't run afoul of the mail fraud and wire fraud statutes.
Well, there may be more. There may be more briefing at a higher level in this case. So we will keep our audience abreast if that happens down the road. But appreciate it, Kyle, for you sharing this with us. We're going to turn now to the latest in our ongoing saga of a fellow walking down the road in Missouri. And so we'll turn to Marie.
Thanks, Anthony. So Short Circuit listeners may remember this case. I'll run through the facts quickly. Our client, Mason Murphy, was walking down the right side of the road, which is a no-no in Missouri. You've got to walk on the left side of the road in most circumstances. But as you might expect, usually this crime is not enforced, at least not with arrests of people walking down the road when they're doing nothing else wrong. But Mason was arrested for doing that, supposedly. That was a pretext. The officer approached him in his vehicle, stopped him, and the officer said he did this because he didn't want Mason walking down his highway. And so then Mason starts challenging the officer's authority to stop him, and the officer was demanding Mason give him his identification. And Mason says, I don't need to identify myself when I haven't done anything that allows you to demand me to identify myself. And the officer dislikes this. They go back and forth for about 10 minutes, and the officer ultimately handcuffs him, puts him in the police vehicle, takes him to jail. The officer at the jail then calls a supervising officer, who interestingly is now the police chief. And he asks this officer, hey, what can I hold this guy on? Basically admitting that he has no idea what crime he could pin on Mason. The supervising officer comes up empty, says, yeah, I don't see anything here. Call the prosecutor, see if he can come up with anything. Other officers at the jail can't come up with anything. The arresting officer learns that there's no warrants out for Mason's arrest or anything like that. So they basically see no basis to hold Mason. Still, they hold him for 2 hours before letting him go without any charges. So then Mason sues, saying, I was arrested in retaliation for exercising speech, engaging in First Amendment activity. Asking the officer questions about his authority and refusing to identify myself was protected activity. Then, after the officer is sued, we learn that, there's this law that prohibits walking on the right side of the road. So I had probable cause to arrest Mason. And the officer says that means that Mason's First Amendment retaliation claim cannot go forward. And in many cases, that would be true. So the First Amendment retaliation claim consists of 4 elements, basically, when it involves an arrest. 1, the person is engaging in protected activity. 2, the government takes some kind of adverse retaliatory action. Adverse action that would chill a person of ordinary firmness from continuing to engage in that activity. Number 3, that the action the government took was motivated by the speech, at least in part. And number 4, that there was no probable cause. But in 2019, the Supreme Court in Nieves versus Bartlett tells us, well, that last requirement about no probable cause does not apply if the plaintiff can show objective evidence that similarly situated people were not arrested for the same kind of conduct absent the speech at issue. So basically, you've got an exception to the no probable cause requirement. If you can show that other people are doing the same thing and they don't get arrested, then your First Amendment retaliation claim can go forward. So the district court in Mason's case says this does not fit the Nieves exception. That gets appealed to the 8th Circuit. The 8th Circuit affirms 2-1. Now, I'll tell you the lineup of judges because it's interesting for the remand. The original opinion was a per curiam with judges Malloy, Kobes, and Gratz, with Gratz dissenting. Then, we petitioned the Supreme Court in May of 2024. That was after the Supreme Court had granted certiorari in another IJ case called Gonzalez versus Trevino. Both cases presented overlapping questions and issues. So while Gonzalez was pending at the Supreme Court, we had petitioned the court to hear Mason's case and said, look, these issues overlap. You should either grant, vacate, remand in light of Gonzalez, depending on how Gonzalez comes out, or just grant the petition. Next, the Supreme Court issues the decision in Gonzalez and grants, vacates, and remands Mason's case back to the 8th Circuit. Okay, so then when the case goes back to the 8th Circuit, the lineup of judges has changed. Judge Malloy took inactive senior status while the case was up at the Supreme Court, and so Judge Malloy is replaced by Judge Kelly.
So not just senior status, but inactive senior status.
Inactive senior status is what the opinion says.
That's really interesting you say, Marie, because I was talking to John Wrench of IJ earlier today, and we were talking about a different judge who's on inactive senior status. And I frankly wasn't sure what that meant, but essentially it means you don't want to fully retire, but you also are like getting up in years, and so you don't want to take any cases anymore. I guess they probably just have the title still and little else.
I wasn't familiar with it either.
Yeah. But in any case, not taking cases anymore, Judge Malloy.
In any case, he's not on the panel anymore.
Right.
And so Judge Kelly replaces him. And before we had petitioned the Supreme Court, Judge Kelly had voted to rehear the case en banc. And so back on remand, we've got a different lineup with Judge Gratz and Kelly.
So that's a pretty good draw, I'd say.
Yes, Judge Gratz and Kelly. So Gratz had dissented before. Judge Kelly had voted to rehear en banc before the GVR. So after the GVR, we've got Judges Gratz and Kelly in the majority and Judge Kobes in the dissent. It's not a per curiam. Judge Gratz wrote for the majority. Judge Kobes did give a dissenting opinion. And the majority opinion makes a whole lot of sense. Judge Gratz is explaining, look, Mason has alleged that he's going to be able to provide a bunch of evidence that the officers usually don't arrest people for walking on the wrong side of the road. And look, he's got supporting allegations for that kind of basic conclusory allegation. He's got video evidence showing that these officers were struggling to come up with a crime to pin on Mason. And just as a matter of common sense, officers are not going to struggle mightily to come up with an offense that they usually charge people with. We've also got in the video the officer saying things like, "Hey, what can I pin on this guy?" And other officers saying, "I don't know, call the prosecutor." So there's a lot of allegations, even if they're not really detailed allegations. There's a lot there to indicate that there's going to be objective evidence that similarly situated people are not arrested when they don't challenge an officer's authority. And Judge Gratz just lays that out there and says, so no qualified immunity on the First Amendment retaliation claim. And he goes into another issue that was still alive on appeal as well. Judge Kobes sticks to the former majority's opinion, saying these allegations are too conclusory, they should fail under Twickball. What's difficult about his opinion is it's hard to imagine how a person could ever allege First Amendment retaliatory arrest, because plaintiffs usually don't have access to the actual evidence of non-arrests, if that evidence exists in hard form without deposing officers.
Yeah. Even if you did a FOIA, the FOIA is just going to say, we don't have anything for you, right?
Right. I mean, you could imagine depositions of officers saying, hey, how often do you charge people with this? How often do you see it? Sure. So there can be evidence in discovery, but you're not going to get discovery before you're filing the complaint. So how do you ever get past the motion to dismiss phase unless you can make allegations like Mason did? And that was Judge Gratz's main point. I think that, look, you've got to take this at the motion to dismiss phase. You got to, you need to draw all reasonable inferences in the plaintiff's favor, recognize that they don't have access to discovery before you can file the complaint. And look, these allegations aren't implausible given the other supporting allegations that Mason has, the video evidence, the officer struggling to come up with a pretext. So that's where we're at. The upshot is the case was reversed and sent back down to the district court. So the claims get to go forward.
So that means that it can go to discovery and then hopefully summary judgment on the merits.
Right. It gets to go forward. Yep. It's not just a, reevaluate qualified immunity. It's no qualified immunity on these pleadings.
Kyle, I imagine you have done some First Amendment work and tried to thread some of these needles.
Yeah, I don't know that I've had a First Amendment retaliation like this, but I've got a First Amendment that I just filed in the First Circuit. I'm thinking about what the next step is on this exception to the probable cause rule. Does the county have to prove that there was no actual or arguable probable cause, or do they actually have to prove that the lack of other arrests of similarly situated people was not pretextual, or is that lack of arrests enough to just make that element not apply at all? What's the issue?
Well, generally, once you, just as a matter of the legal framework, once you get past the Nieves no probable cause exception, you go into the Mount Healthy framework. But I'm not sure. I think this could come back up at summary judgment possibly for a showing of the objective evidence.
Right. Because it seems like, in any event, you probably have a good case that there was no actual or even arguable probable cause based on what they wrote in the opinion, right? But it would be, I guess, better for you if you could simply show no one else in these circumstances gets arrested.
Right. Well, at this point,
and if that were enough to win, that'd be great. Yeah.
Probable cause was conceded.
Okay. All right. Fine. So you're not fighting that battle. Your battle is just to prove that this is pretextual.
Right. That it fits within that Nieves exception, the carve out. Sometimes it's called the jaywalking exception because the court used that example. Lots of people jaywalk and aren't arrested. It's hard to imagine a closer scenario than what Mason did here, walking along a road instead of across it.
And it's really even more minor than jaywalking because, like we discussed, I remember last time you were on, I literally did not know that this was a crime in many states to basically walk with the traffic instead of against the traffic. And that's because no one ever charges it.
Right. I mean, you're not even going out into traffic.
Right.
Was this a divided highway or just an undivided road?
It was an undivided road, one lane each direction, but it had a large shoulder on each side.
I mean, growing up in Texas, everyone knew not to walk on the divided highway. That would just be absurd. But there were signs that said, no animals, no people, no pedestrians. But if this just sounds like a road with a highway number. That's what people do. We walk along roads.
One final quirky thing that is interesting in the facts is they also threatened to charge him with not giving his identity. But it turns out that is not a crime in Missouri to not give your name when an officer asks.
Right. Sometimes it is and sometimes it isn't. The officer needs a reasonable basis to demand it, depending on why the person was stopped to begin with. And here they're even if the officer knew that walking on the wrong side of the road was a crime, that's not reason enough to demand identification. So and I mentioned earlier that the person the arresting officer called is the now police chief. Interestingly, in May, that police chief issued a statement, kind of trying to explain the situation and say, the arresting officer was a part-time officer and resigned after this incident, and the police department is under new leadership and does not condone this kind of behavior. Just an interesting little tidbit of information. In the letter, he does not state that he was the person that was called during the incident and couldn't come up with a crime.
Well, the plot thickens. We'll see how that does on remand. So Institute for Justice is not actually going to be part of the remand. Is that right? But of course, we'll be wishing our co-counsel well and see what happens there.
Right. The original counsel is handling the case at the district court level. Okay, great. Well, we will, as I said, see how that goes. We will see how things go for Kyle as well. Kyle, thank you for joining us on Short Circuit.
Thanks for having me. I had a great time.
And thank you to everyone else. I'll close by saying we hope to see some of you in Chicago, as I said, on August 17th. And Marie's going to be at that same conference at Chicago.
Be there.
So not only would you get to meet myself and John Ranchavijay, but also Marie. And so please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, on all other podcast platforms. And remember to get engaged.